I'm going to give you an introduction to the language of criminal law. Yesterday it was civil law, today it's criminal. And I look at it under the following headings: the legal profession and the courts, some language of criminal law, the rules of criminal procedure, and also one thing I don't mention on these slides is that I will talk a bit about what we saw yesterday, what some of us saw yesterday at the just over the road in the Court of Appeal Criminal Division. We're already familiar with these terms, that a lawyer is a solicitor or a barrister. We know what a judge is. Magistrates, there are two different types. You have what is called a bench, so that is a collection of 3 lay magistrates, not lawyers but helped by a lawyer, and a district judge who used to be known as a stipendiary magistrate, and he is a paid lawyer who acts as a judge in the magistrate's court. The district judge sits in cities, and he sits every day because there is enough crime, whereas the lay magistrates sit, say, perhaps once a week in small towns and in rural areas. We've touched on the word lay magistrate from the word layman, and I think it's originally from the Italian, laico. The church. So you have the members you have the priests and you have the laico, and so who aren't members who aren't priests. Yeah, and it's the same like the lay magistrates. They're not experts. So when it comes to accountancy, I am a layman. Yeah, I'm not an expert. The system of magistrates is very old, and magistrates are also known as justices of the peace, or JP. So, which court? Magistrates' court or Crown Court? Let's look at the structure of the courts. You'll see at the very bottom there, bottom left, the Magistrates' Court, and above it the Crown Court, and with appeal to the Criminal Division of the Court of Appeal, which is where some of us went yesterday. If the offence is a minor offence, which we call summary offences, they are tried in the Magistrates' Court. Serious offences are called indictable offences and are tried at the Crown Court. Some offences can be tried in either at the option of the accused. Yeah, here's the choice. As I said, over 95% of criminal cases are heard by the magistrates, and the maximum penalty they can impose are 6 months in prison or a fine of £5,000. In a Crown Court, there are no magistrates. You have a judge and a jury of 12 people chosen at random, 12 normal citizens who aren't lawyers. I've been a member of the jury twice. It's quite interesting. The role of the jury is to answer the question, on the evidence presented, am I certain that the accused is guilty? And the role of the judge is to make sure that the trial follows the rules of criminal procedure, and then, if the jury finds the accused guilty, it is the job of the judge to pass the sentence. With appeals, it gets a bit complicated, and it's a question of various things. Is it an appeal from a decision of the magistrates or from the Crown Court? Did the defendant plead guilty or not guilty? Is this an appeal against conviction or against the sentence? Conviction means that I have been found guilty. Yeah? You are convicted of the offence. Does the appeal involve a question of fact or a question of law? So those are the questions you have to consider when deciding what rights of appeal exist. And I'm not going to say any more about that. Now, let's remember where we are in the structure of this talk. That was just, if you like, I was setting the stage, giving the background in which trials, the background to which, I was showing you where trials take place. Now let's look at some language of criminal law, and we will look at offences, defences, and the parties involved. We'll look at this in the four headings. Mens rea and actus reus. Do you use those terms? No, okay, you don't, even though they're Latin terms, okay. The possible parties to an offence, the inchoate offences, and some defences. Okay, so mens rea and actus reus. Actus reus is the elements of the offence except the mental element, and mens rea is the mental element. And it's not needed in what we call strict liability offences. Let's look at some examples. Murder, the unlawful killing of a human with malice aforethought is the traditional definition, or intention to kill or cause grievous bodily harm is the more modern definition. Grievous means serious, serious bodily harm. Then the definition of theft, to dishonestly appropriate, which means to take here, it's a verb to take, property belonging to another with the intention of permanently depriving him of it. Now, a little bit of an aside about theft and similar crimes. So theft, you take somebody else's property and you intend to keep it, okay? Burglary is theft plus trespass. And trespass means going onto land or into a building unlawfully. So burglary, you break into somebody else's house and you steal stuff. That is burglary. Robbery is theft plus either violence or the threat of violence. I've got a gun, give me your money or I shoot. Okay, that's robbery. So a thief steals and the offence is theft. A robber robs and the offence is robbery. A burglar burgles and the offence is burglary. Now, back to actus reus and mens reus. An important part of proving actus reus is causation. And we've talked about causation slightly when it comes to civil litigation, because there's always a question, yes, you breached the contract, but did it cause your loss? Yes, you committed, there was an act of negligence by you, but can you prove that it's caused you loss? Yeah, it's causation. So again, there has been an act. Can we prove that that the act caused whatever happened? Now, in the case of murder, are we certain that it was the defendant's conduct which caused the death? And there is learned discussion. They look at, was it a substantial cause? Might there have been other causes? Was there any intervening event? Was there negligent medical treatment? Now, those are all the issues which you take into account when deciding whether there is the necessary actus reus for the offence. But, here we're talking about quite specialist things, and usually it's pretty clear the man has been shot, he is dead. It's pretty clear that the shot killed him. Now, with mens rea, the states of mind, there are 4 states of mind which can constitute mens rea. The first we saw with murder and theft is the intention. You need the intention to cause serious bodily harm or to kill. You have the intention to deprive him of his property and to keep it. A second category of mens rea is recklessness. You drive recklessly, you just don't care. So that's recklessness. Negligence is not very common, and don't confuse negligence here with the tort of negligence. That's a totally different thing. That's a civil matter. Here, it's the mental offence of the mental element is rare in criminal cases, and it happens with a crime called manslaughter. Okay, Manslaughter is when somebody has been killed, the court cannot prove, or the prosecution cannot prove that the accused intended to kill him or to cause serious bodily harm, but they can prove that he was negligent, he was careless in what he did, and that's the lesser offense of negligence. Now, blameless inadvertence just means, well, it happened, and this is with what we call strict liability offences, because with some offences you don't need to prove the mental element. In some offences, the very fact that it happened is enough. And an example is, you are driving a car and with more alcohol than is in your breath, in your blood, than is allowed by law. That's it. The mental element does not come into it. You don't have to consider it. Similarly, with food, the laws on the storing of food for sale. Certain foods have to be kept at certain temperatures. If they are not kept at those temperatures, you have committed the offence. You don't need to think about there's no mental element. Okay. How did we get up? Yes, I used the word driving with the blood above the prescribed limit. So let's look at this word, prescribed limit. It means the limit set out or set down in law. But let's look at some very similar sounding words which are very different. Prescription. If you're feeling ill, you go to the doctor, he gives you a prescription for certain drugs which you can't buy over the counter. You can only buy them with a prescription, and you get that from a pharmacist. We talked, the word prescription has got very strict legal meanings. One of them Sarah discussed with her when talking about property. If you use a lane, a right of way for 20 years, you gain, and not secretly and without objection, you gain rights by prescription. In some legals, there is also something called limitation. I don't think I've mentioned limitation yet. And you have what is called the statute of limitations. And after a certain period, you can no longer bring an action for, let us say, breach of contract. Yeah? And with breach of contract, that period is 6 years under English law. 6 years from the breach. If you do nothing, you've lost your chance. And we call that limitation. There's the Limitation Act. But I think in some jurisdictions they call that prescription. I'm not sure. Yeah? Do they do that? Yeah. Now, that was prescribed. Look again at the second word, proscribed. A proscribed organization. If something is proscribed, it's banned, it's illegal. The IRA is banned in this country. Al-Qaeda is banned. In your country, there are people who are banned, proscribed organizations. Okay, so that was mens rea and actus reus. Who are the possible parties to a crime? Well, you have the principal party. That's the main party. But again, another aside. Look at these two words, principal, A-L, and principal, P-L-E. Lots of meanings, and be careful not to confuse them. Principal, main, not secondary. You have the law of agency, where the principal is the main guy who employs an agent to buy and sell goods for him. In money, you talk about repaying principal. If I borrow £100 from you at an interest rate of 10% per year, at the end of the year, I have to repay £100 principal, and I have to pay £10 interest. Now, principal is different. It's a moral rule. That's the definitions in the red. A moral rule, the idea behind something, an agreement in principle, and the rules of a process. So you object on principle. You object as a matter of principle. You talk about something being a basic principle of English law, that you are innocent until proved guilty. You talk about, as Sarah said on contracts, you have agreement in principle. Yeah, we think we've understood. We think we've agreed. We signed the heads of terms. Is there a contract, a legally binding contract? We had that discussion, but probably not. And then the last meaning of principle, you have Archimedes' principle. It's the rules of a science. It's a scientific process. So the secondary parties. The main party is the guy who, it is alleged, has committed the crime. Now, you can also have people who aid the criminal by helping him. You also have people who abet the criminal by encouraging him. You have people who counsel the criminal by giving advice. Okay, you want to rob a bank? This is how you do it. Okay, that's counseling. Procuring is if you're Mr. Big in the criminal organization, do you go around and kill your enemy? No. You get some junior guy to do it. Yeah? So you procure that somebody else does the dirty work. So we'll move on to what are called the inchoate or incomplete offenses. Incitement. Go on, kill him. Yeah? You're inciting, you're encouraging, or even threatening, or even pressurizing somebody else to commit a crime. Go on, kill him. Conspiracy. I'll tell you what, it'd be a damn good idea. Shall we blow up the Houses of Parliament? Yeah, I've got some gelignite. Let's go on along this afternoon. Let's do it. Yeah, good idea, Alan. Let's do it. Okay, that's a conspiracy. And I say let's blow up the Houses of Parliament because, have you heard of the gunpowder plot? Yes. Yeah, 1605. And we celebrate every year on November the 5th the fact that the gunpowder plot, which was a conspiracy to blow up the Houses of Parliament, that it failed. And the leader, Mr. Guy Fawkes, was caught and put to a very painful death. And we celebrate by burning an effigy, so a model of Guy Fawkes, every year on the 5th of November. Anyway, that was conspiracy, an attempt to try to commit a crime, but to fail. Now, they're offenses in themselves, unlike secondary participation. So we commit the crime of conspiring just by sitting down and forming our plan, our intention. If we're caught before we've blown up the Houses of Parliament, we've still committed the crime. If we go back to aid, to abet, to counsel, to procure, the main offence has to take place. Yeah, you can only aid an actual crime. You can't aid a crime which doesn't take place. Now, interesting sort of almost philosophical point. What if the main offence doesn't happen or is impossible? Is it still a crime? We said that with conspiracy, yes, it is still a crime. With incitement, go on, kill him, go on, kill him. It's not a crime, but there are specific crimes, such as to incite, the incitement of racial hatred. Can you remember the exact word? Incitement to carry out acts of racial hatred or something. That is a specific offence. Now, an attempt, this is the one that law professors love. Do you know pickpockets? Yeah, a pickpocket. You'll be careful of pickpockets. Piccadilly Circus, you know, very crowded. Somebody puts his hand in your pocket to try to steal your wallet, for example. That is a pickpocket, okay? But what if he puts his hand in your pocket and it's empty? There's nothing there, okay? You haven't got any money, yeah? You haven't got any money. So yes, it is, the law says it is an offence to put your hand into an empty pocket. You still commit the crime. Now, those were the crimes. What are the defences? There are 7 there. Insanity is a medical condition. Automatism, you are not legally insane, but you are unable to control what you do because, for example, you are concussed. Concussed, you've got a knock on the head. Yeah? Or you are in a hypnotic trance. I won't try to imitate that, okay? Okay. Now, if it is self-induced, it is not a defense, okay? So if you, yeah, it is not a defense. Now, the difference between insanity and automatism, they can be small. Yeah, and you have experts arguing as to whether this man is insane or whether he was acting as an automaton. But the consequences can be very different, because if you're insane, you are sent to a mental institution, and if it was found you are acting as an automaton, you may be found not guilty. Yeah? So very different consequences. Mistake. Mistake is not really a defense, it is a lack of mens rea. You see two people and you think they're fighting, and you go and get hold of one of them because you think he is attacking the other guy. But actually, this guy is a police officer arresting that guy. Okay, so you haven't assaulted him. There is no mens rea. Okay, because you did not have the intent to hurt him. You had the intent to save him. Intoxication. This is a complex issue. It depends whether it is voluntary or involuntary, and on the nature of mens rea. Now, what is involuntary intoxication? What if I say to you, somebody has spiked your drink? You know what I mean? You think you're drinking wine, but actually somebody's put 3 centimeters of vodka at the bottom. Yeah, that is spike. That is, if you like. So you don't realize it. That's involuntary intoxication, perhaps. Self-defense. Yes, if somebody attacks me, I'm allowed to defend myself. But the amount of force I use has to be reasonable and not excessive. And there have been cases involving, there was a farmer, a sort of fairly elderly gentleman who lived on his own in the country. People came to rob him, and he shot at them. Was this reasonable or not? He went to jail, didn't he? Yeah, but he's now been released. I forget the circumstances. Duress. You are forced to do something to avoid death or serious injury to himself or another when threatened by a third party. Okay? If you don't do this, I will hurt your child. That duress can be an offence to certain crimes, but not to murder. Now, necessity, the defence of necessity in a crime. Just think, you're saying, I had to commit the crime. And there's a famous case which all law students love, Dudley and Stevens from 150 years ago. These sailors were shipwrecked. In other words, the ship sank, and they were left on the small lifeboat. 3 of them. Now, the cabin boy, who's a young boy, I don't know, 14 or 15, who was on the ship, he was on the lifeboat. He was very weak. He was almost dying. The other 2 killed him and ate him, what they call cannibalism. Okay? And somehow, I don't know how, this was discovered. And they were tried, and it was said the necessity was not a defense to murder, and these people were sentenced to be hanged. But that sentence was reduced to 6 months in prison because of public outcry. Okay? So that's, my point is that necessity can be a defense, but in very limited circumstances.